Oh, right, we're recording. Okay, so we're gonna go into dot loop and we're gonna set up the loop for the offer process itself. So you go to add loop. Now, again, what I love about dot loop is it auto pulls information. So we're gonna take the address 24009 Misty Lake, and it pops up saying that it is listed. What's interesting is it doesn't have the MLS number, but I'm sure it will. You click on it, hit continue. This is a buying loop because it's not our listing. I'm not going to upload the photo. You're welcome to if you want to. And here's the loop itself. I'm going to click on it. And there's a bunch of forms. What I've realized, and I keep saying I need to do this, so I will get this done today. The 1 to 4 is not actually in here in the template, which I know why I didn't do that, because technically when you're buying a property, it could be 1 to 4, it could be a lot, it could be new construction, it could be farm and ranch. So I didn't automatically put a contract in here, but I probably should just have the 1 to 4. If you ever need to add a document, you literally go to add a document, templates, and then down here, the Texas Realtors Interactive and the Houston Association. These two folders have every form you need. So any form that's been created will be in one of these two spots. So in this case, I'm going to go to Texas Realtors and I just type it in so that it pops up and I don't have to run through it all. I check it off, hit copy. And now it is in my file. Now remember, when you're working with a buyer, there are two forms we automatically require as a brokerage. Well, one is automatically done by TREC, which is the information of broker services. I have a templated one in my dot loop already with all my information. And the other one is the general notice, which I am so glad we're doing this through this because it's not in here either, which I don't know why that is. So I also require the general information and notice to buyer. Now we're going to go through actual addendums and these documents tomorrow. But know that these two are required from the brokerage. The other one you want to get is the buyer's representation agreement, which that one is not required because that is an actual contract between you and the client. So you can't make someone sign it. However, I highly recommend you use it in your business due to the fact that if they try to move you out of the deal, it protects you. So this is what the residential buyer agreement looks like. And again, we're going to go through this more tomorrow. But I want you to be aware of what it looks like. Okay, let's just jump into the 1 to 4 because that's what we're here for. So when you go into dot loop, the first thing that's going to pop up is the autofill. If your buyer uses electronic documents, like is willing to electronically sign things, I highly recommend doing this right off the bat, because otherwise it's going to be annoying having to go back and do it later. So I'm just picking some buyers of mine just to use for reference. It's not going to send them anything. Oh, her legal name. And always remember, side note, you must use legal names. That's a big one because if you don't use their legal name, you're going to have to amend the contract. So make sure you ask, like this client goes by Becky, but her real name's Rebecca. So I'm not going to put Becky on the contract. I'm going to put Rebecca on the contract. So that is important, especially I'm going to use the word cultural clients because a lot of times they have more than one last name and they don't necessarily tell you up front. One way to get around that is just ask them for a copy of their ID, and then you can use what's on their ID for the contract itself. Seller name, you don't represent the seller, so you don't need to do that. I would be the buying agent, and then the buying broker is Inc. That's all you need, and then it will automatically put the contract. You could put the purchase price in there if you wanted. I don't do that right away. It auto fills the listing agent's information and then the rest we'll do later. So now I'm going to hit autofill. And it will put my client's name, the property address, and then at the end, you'll see that it auto-filled some items too. So first off, you do not use this for condos. You only use it for townhouses up to 4 homes. So a multifamily with 4 units. That is what the 1 to 4 stands for. Condos are on a separate contract. Lots, unimproved lots, or improved lots, depends on what's on it. Like if there's a house on it, it's a 1 to 4. If there's just like a shed, that would still be a lot contract. So this is for 1 to 4 only and not condos. That's a whole separate contract. So the first section is literally your client's names. So we got to look for the seller, which here is the property. I would highly advise having this up when you're writing an offer. So to find the owner's names, you can click on tax account number, and there's multiple ways to do this. This is how I learned. Many of you, all of you are newer. So since I've been in real estate, they keep changing Matrix or whatever database we use. And on top of it, like this bar right here was not here like 5 months ago. So how I teach you is how I learn. And so just know that there might be different ways to find this information. This is how I do it. Okay, so I click on tax account number. And you know what? I can't do that because you guys don't see the tax account screen, do you? Nope. Okay, so we're gonna do it on here just so you can see it. If I click on here, the owner name is this. I'm not gonna even try to pronounce that. So I copy it, then I literally paste it on the contract. So there's the seller's name. If it's wrong for any reason, the listing agent should correct you when you submit the offer. You might check the agent remarks to see if maybe they tell you something different, but it doesn't. It does say, please see attached offer instruction for contract preferences. So if we go here, we're gonna look here. and it tells you what they want. Please check number 2 under survey. Please ensure 1%. We have one of these too, by the way. So this is just a good reference. Let's go back. Okay, lot block. So the second part is the property. So recently we're having a situation around this. So just to note that it's very important to make sure that this section is correct, because this is what the contract is conveying. We are a real estate agent who helps buy and sell real estate, which this is referencing to that real estate. So make sure it is the correct lot, the correct block, and the rest of the legal description, which is right here under legal description. So what I do is I copy this, lot 14, block 2, lot 14, and I paste. Now, if there are multiple lots, you need to make sure that what I've just officially learned, that if there's 2 parcels and they are not merged, that should be 2 contracts, not 1. Now, if it's 2 lots with 1 tax ID, then it could be 1 contract. So you just need to make sure you are aware of what's happening with this, with the property. And if you have any questions, that's what I'm here for. But in this property itself, it just has 1 lot. You would have seen lot 14 and 15 if it was 2 lots, but then you would verify on the tax record that those don't have 2 separate parcel IDs. When we talk about running a CMA on Friday, I get deeper into parcels and knowing property lines and all that. So I'm not going to go too far into that right now, but just notice if they say, well, this lot is sold with the lot next door, you just need to double check that they're not 2 tax IDs, because that will be 2 separate contracts. Okay. Now, these 2 sections are very important and often missed. So 2B is improvements. This is basically what I say is, if you flip the house upside down and if it doesn't fall off, it's a fixture, it's attached to the house and it's supposed to stay. Now, from a buyer standpoint, you essentially don't write anything unless there is exclusion. So right here, it says under the interior exterior section, exclusions, see exclusion list. So if we go back to the attachments, look at disclosures. I'll go ahead and download this for our reference to put it in the loop. But if we scroll down, there should be, and there's not. So I do not see an exclusion list. Do y'all? Nope, that's the notice. So there's no exclusions from our understanding. And so those would be all garage, the house, the garage, and all of their fixtures permanently installed. So that's valances, shutters, awnings, wall-to-wall carpeting, mirrors, ceiling fans, attic fans, mailboxes, television antennas, mountain brackets for television and speakers. That's the biggest one we find fights in, because if you think about it, if you haven't told your client that the brackets and mounts stay and they take them, but they don't patch the holes and repaint, then the new buyer gets typically pissed that they walked in and now there's a bunch of holes in the wall. So one of the things two things need to happen. You need to make sure on the listing side to let your clients know. And if on the buyer side, during your walkthrough, I really, really don't like to have a walkthrough before they're moved out, until they're moved out, so that I can understand what it's gonna look like. But it's nice to always just remind, oh, by the way, are they gonna patch those holes if they're gonna take the TV mount? Because some people still take it, even though it's supposed to stay. And depending on how important it is to your client is how you negotiate at the time of walkthrough. Obviously, heating and air conditioning units, security and fire detection, wiring, plumbing and lighting fixtures, chandeliers, water softeners, big one, kitchen equipment, garage door openers, cleaning equipment, shrubbery, landscaping, outdoor cooking equipment, and all of their property. What's funny is this section used to be a lot smaller, and then every year something new gets added because obviously there was a fight about it. Like shrubbery was not always in there, but clearly someone took all their shrubbery, which makes me laugh. But it is in there. So make sure on both sides that you're aware of that for the walkthrough. Accessories, window air conditioning, stoves, fireplace screens, curtain and rods, and the blinds, which is also the other big one that ends up showing up a lot more. Window shades, draperies, door keys, mailbox keys, above ground pools, swimming pool equipment, fireplace, artificial fireplace logs, security systems. Okay, so this is the new one. And there's more later on in the contract, so I'm just gonna kind of lump it in right now. Security systems that are not fixtures. So they have now stated that anything that is controlling a house system, like garage doors, lights, security, what's another one? Garage door, light, security systems. I think that's the main ones. Music.
With like a little echoes, you know, how
Yeah.
sometimes people.
So the
Okay.
Echoes and the Alexas and the Google Homes, that is all considered a fixture if it controls some, like a Ring doorbell, Ring units that are placed throughout the house. Those would all be now fixtures, like the actual unit that controls it becomes a fixture, which it used to not be that way. So people would take the Ring or the Google Home or the Echo, and then they've got these systems and people can't use them or without buying the piece for it. So now you have to let your client know you either need to disconnect that system or we have to exclude it. You can exclude it, or it technically stays with the home, which honestly, if you don't really make sure that that's excluded and your client is aware of that, they're going to be mad at you if they lose their Google Home, or you're going to have to end up buying the buyer a new one.
Or so in those cases, make sure they have it in their seller disclosure then, right? If they want to take it with them.
So
Like,
it's not the seller's disclosure that will say that, it's an exclusion list. The seller's disclosure just discloses what's currently in the home, but you have to actually state that it's excluded on the MLS, and we have an exclusion list for template for the brokerage. You can have your client fill that out and sign it and disclose it.
So does that mean that also with like staging material, I've seen some listings that like in the exclusion list, they like make sure they emphasize staging material goes with the house once we sell it, like we take it back.
Yeah, I would just always reference, I mean, staging material is typically not a fixture unless it's curtains. That's the only thing that's really considered a fixture. So I've seen people write it. I mean, over disclosing is fine, but it's really not necessary. The biggest items are those Googles and Alexas and Nests and Rings. All of that stuff is now considered a fixture. And then staging material, it would be mainly if they use blinds. But here in exclusions, D is where you would either write a single item or you could put see exclusion list attached. So if you used our list, then you want to make it a part of the contract. And so you would then have both parties sign it and make sure it is signed and attached to the contract at the time of execution. Okay, now the fun part, making an offer with the price. So if we go back to the property, so this is obviously overpriced. It's been on the market for 855 days. So we're not going to offer 875. I'm not running a CMA today because that's not what we're here for. However, I'm just going to go ahead and say, let's offer 800,000 because that's fun. Let's get a deal. So for some reason, it's not letting me put in the contract price. Maybe it auto sums it for me. So the first section is the cash portion. So this is dependent of how much they're putting down. So if this is a jumbo loan, by the way, so if you don't know what a jumbo loan is, it's off of, I know it changed this year, jumbo loan limit. Let's see what it is exactly. 647,200. So you have to make sure that you're working with a lender that does jumbo loans. But let's say they're putting 20% down. So 800,000. Wow, my brain. So 1600. This is how much is being financed. And I don't know why it's not doing it. Maybe. Oh, does it at the end? Okay. That's new then, because I've never had to do that before. So let's just see what happens. That's supposed to say 800,000. If it doesn't by the end of it, I'm gonna have to figure that out. Something went wrong. Oh, there you go. You're right. Good, thanks, Sinai. That's new. Dotloop just added that feature recently. Okay, so that's nice little not have to do math. Make sure that you check off one of the financing. Since there is financing and it's not cash, you have to check off either third party, loan assumption, or seller financing. If it was cash, you wouldn't do anything under B, and this would be left blank. So any questions in this section? It's pretty self-explanatory, but if there is just a cash offer, there'd be nothing in B, and it would be the same amount on A and C. Okay. Leases. I should not see anything checked on this unless there is an actual lease involved. I've seen some people check it off. This is newer, so I get we're all learning it. However, only if there's a actual residential lease involved. So someone is renting the property currently when you are buying it, you would check off A. If there's a fixture lease, such as a water softener, propane tank, solar panels, security system, any type of fixture lease that would stay with the property, you would check B. And then natural resources. So if there's any existing oil and gas, mineral, water, wind, or natural resource leases, then you would check one of these off. We rarely see C. I do see A and B often. And so just be aware that if there is a residential lease, you want to check A off. And then because there is an addendum for it, and that addendum then gets your client the rights to get the copy of the lease, to understand the credit and background history of the client, the pay history of the client. It gives your client more information, especially for investors, knowing what type of tenant is in their property. Okay, earnest money and termination option. Obviously, one of the most important sections, because this is the only section that is time is of the essence in our contract. So what that means is if these days are not followed, then things actually automatically happen. In the rest of the contract, it's kind of like, well, if you don't meet these days, then it automatically extends, and there's all this lingo involved. But with the earnest and option, it is matter of fact. If you don't do it, it will either end the contract or it will just lose your rights. So this is very important. Now you must deliver option and earnest within 3 days of the effective date to the title company. So the first line is the title company's escrow agent. I see it both ways. You can put the escrow agent or title company. It hasn't been an issue doing either. You could do both, either way. This is the address. The first is the option or the earnest money amount, which is typically $1,000 or 1%, whichever is greater, or whatever your client wants to offer. It doesn't have to be 1%. A negotiating tool in a multiple offer situation could be a buyer willing to put more down for the earnest money. But please be aware that if you advise your client to do that, you better watch these dates 500%, because if something happens, then that money could be liable. And then again, we could be liable for that money too. So I've had a client put his entire down payment as the earnest money to win the offer, because he knew he had to pay it anyway. So why not use it as a negotiation tool? As long as you follow the dates of the contract, then you don't lose that money. So 3 days, let's just clarify what this means. And also, I guess I should finish this line. The earnest money and option fee shall be made payable to escrow agent, title company, and be paid separately or combined into single payment. This is new this year, so it used to not be this way. So you'll may still have questions from agents like, oh, do you want one? Do you want two? Where does it go? It all goes to the title company. It can be one check or separate. It doesn't have to be certified funds, and yet you still have to get it there within the timely fashion. There's an additional money section to escrow agent within blank days after the effective date of this contract. I've honestly never used that before. I've never seen a scenario where that's needed. So I always leave it blank, but I'm sure someone's used it for something. Now, this is another key thing. If the last day to deliver the earnest money, option fee, or additional money falls on Saturday, Sunday, or a legal holiday like today, the time to deliver is extended to the next business day. That's not a Saturday, Sunday, or legal holiday. So for example, let's say your effective date was Thursday, this past Thursday. So what was that? I don't even know what day today is. 17, so 16, 15, 14. Would that be the 13th?
13th, yeah.
13th, okay. So your effective date's the 13th. So day 1 of 3 is Friday, the 14th. So you've got 14th, 15th, 16th, which is the Sunday. Well, today's a national holiday. So technically tomorrow is day 5, but is the day that earnest money is due. And option money is due by 5 p.m. Now, I will say earnest money technically is allowed to be paid by, it's funny because they should have just done this. I'm reading to make sure I didn't miss this, but earnest money is paid till midnight, but option money is paid till 5 p.m. Oh no, that's termination. Never mind. So technically it's till the midnight, but title companies close. So I highly recommend that you tell your client that it's due by 5 p.m. on the 3rd day. Well, in this case, it wouldn't be due until the 5th day at 5 p.m. So just be aware that a Saturday, Sunday, or legal holiday, it goes to the next open business day. And day 1 is the day after the executed date. So if we're executed today, the 17th, day 1 is the 18th. Any questions, any confusion around that?
Yes.
Okay, yes,
You said auction days, it's 3. It's the 3rd business day, right?
yep.
And it was another one that was 5 days. Which one was that?
So that's only because of the example I gave. So it's always 3, but earnest and option is always 3 business days unless it falls on a Saturday, Sunday, or a legal holiday. Then it moves to the next business day.
Okay. At 5 p.m., right?
Yep. Now, you're going to hear 2 different versions of this. And I'm going to give you the broker's version first, and then I'm going to tell you my version. So I'm going to split myself for a second. So a broker would tell you, don't touch the money. Make your client pay it themselves, whether it's deliver it or honestly, with COVID, title companies have moved to online payments for this stuff. So most title companies have made it super easy to let your client pay online through a portal. So it shouldn't be that difficult to get the money there. Also, you could request a overnight FedEx label. Title companies will provide FedEx labels for your client to overnight the money. So on a broker standpoint, if you don't touch the money, you're not liable for the money, right? You could be liable if you touch the money and somehow it didn't get delivered. From a customer service top agent standpoint, I figure out how to get the money there in any whatever situation may like, let's say they're out of state or they're out of the country and it's just not feasible to get it there in time for whatever reason it is. I have written a check on behalf of my client, and my client has like Venmo'd me or PayPal'd me. This does happen if they're elderly and they don't want to drive, or we know that some people don't have Zelle and technologically challenged, I make it happen. Like, I'm not gonna let the 3 days pass because my client can't pay online or can't get to the title company. But no, the more you touch money, the more you could be liable for it. So just be very clear of that. Like, if you're gonna pick it up, you better make sure that you take it there in time with a receipt at the title company. Okay. Now, just side note, title is a non-biased third party, so they will hold that money until either the contract is terminated or it closes. And then at that point, it depends on the situation on where the money is released to. If we have a highly successful transaction and it closes, then that option and earnest money is refunded to the buyer. If we don't have a successful transaction and the buyer's within the rights and everybody agrees, then it goes back to the buyer. If the buyer is not within its rights, it goes to the seller. Or option money is automatically lost if you don't close, but earnest money is the one that's up to question depending on the situation of the contract. What happens if you don't deliver it? Earnest money, if the buyer fails to deliver the earnest money, seller may terminate this contract or exercise seller's remedies under paragraph 15 or both. And then failure to timely deliver option fee, if no dollar amount is stated as option, or if the unrestricted right, or if buyer fails to turn it in a timely manner, then they don't have the right to terminate anymore. So that's obviously really important. If they do plan to have an option and don't pay the money on time, they don't get to cancel the contract based on the option period. The option period gives the client the unrestricted right to cancel within those time frame. So that's where B is. For the nominal consideration, the seller grants buyer the unrestricted right to terminate within so many days. In a buyer's market, we find that this was 10. We've seen it go less and less based on negotiation. So I've seen 0 waiving the rights, and I've seen like 3 to 5 days. I mean, you still got to get an inspector out there if you are going to do an inspection. And so typically you need at least 3 days to do the inspection, read it, and negotiate. Otherwise, just waive the inspection if they're not going to do one. But you'll need at least 3 days realistically to negotiate if you're going to have an option period. Your clients have to make a decision whether it's negotiating or terminating by 5 p.m. on the last date after the effective date. So again, the effective date is super important to know. So if today we execute, today's the effective date, and day 1 starts tomorrow. So everything goes off of tomorrow, day 1. And so if we put 5 days, and so then we have Tuesday, Wednesday, Thursday, Friday, Saturday. Saturday by 5 p.m., you would have to either have a negotiation amendment or a termination given to be able to cancel based on the option period. Any questions around this before I move on?
Question.
Yes.
So by 5 p.m., you just have to have the negotiations and it has to be signed, or does it have to be turned in to title with the negotiations?
Just signed. So it's only between you and the client, or you and the buyer and the seller. But know that the agents are involved. So execution is signed and delivered to the other representing party. So it doesn't have to be the title, it doesn't have to be to the mortgage lender, but it has to be to the representation, the agent representing the client.
Got it.
So it just has to be between you two. Good question. Anyone else before I move? I want to side note because I just had this come up, and this didn't come up through the option period, but we find this happen a lot. So I want to make this clear of what happens. So what we've seen is if we can't come to an agreement, like if we're the buyer and we've been negotiating repairs and we just seem to not come to an agreement and it is creeping up to 5 p.m. on the last day, the only way to protect your client's earnest money around option, okay? So there are other ways to cancel through the contract, but if your client's a strong buyer, if the house appraises, if there's no title issues, it is very unlikely that you'll be able to cancel. So the only way to protect your client's earnest money for sure is to cancel before the option period. And so if you don't submit that termination before that 5 p.m., because your client and the seller can't come to an agreement, but they don't want to necessarily kill the deal. But if you don't have any decision and you just let the option period pass, your negotiations don't have to continue. The seller does not have to continue the negotiations after 5 p.m. I want to make that very clear because that has happened on the buyer side, especially with newer agents, that the seller is in the stronger position if buyers trying to negotiate repairs and they just let the clock tick. You can be mad all you want that communication sucks. If the clock is ticking to 5 o'clock and you don't have an agreement, then you better throw that termination into the email to the other agent, the listing agent, to protect your client's rights to cancel and get their earnest money back. Now, a termination is a one-way document. Once you terminate, technically the deal is terminated. Now, if the seller wants to agree and come back because a title company and a lender doesn't have that document yet, you could still just kind of get rid of that document and sign whatever document is now agreed upon. But please realize that without that termination in that agent's inbox by 5 p.m., your client no longer has power to negotiate anything until the appraisal comes around or maybe a title issue. But don't be that agent that lets it go past 5 p.m. because you think you're going to get a response. Questions?
So
Yep.
I'm saying this because I'm going through something right now. So on one of my listings, the agent, she sent me something during the option period for repairs.
Yep.
And I sent it back with box number 7 check to terminate their, remaining option period. Like we agreed, but to,
Yep.
So-
To waive it. Yeah. To get
right.
to end it.
So-
Yes.
So I sent it their repairs back with box number 7 checked, and the agent, I think we had like a day or so left, and I texted her letting her know, hey, sent you back a document, and it was after 5 o'clock. Fast forward, I didn't hear anything. Fast forward after 5 o'clock, but I told her, look, we agree to it, but hey, just sign our form. And after 5 o'clock, nothing. It was like 8 o'clock and I called her. I was like, hey, we haven't gotten anything. Even though we'd already obviously agreed to everything, you know. So at that point, they're at my seller's mercy, I guess, because it's past 5 o'clock, right?
Correct.
Even though we've already told her, hey,
It's not in writing until it's executed. So,
okay.
yeah, I mean, so there, that becomes, I want to say ethics versus legal. I mean, ethically, I mean, I still don't see necessarily the seller being a bad person if they change their mind because the other side didn't do what they were supposed to do. So if the seller comes back and says, you know what, I don't want to do that anymore, they're in their complete rights to change their mind. Now some sellers wouldn't do that and some sellers will, and that's the gamble you have. If you don't put that in a timely fashion, that seller could absolutely change their mind, because if it's not in writing and it's not executed and sent over, and make sure, I mean, technically, they have said that if it is sent and it didn't get sent back to you, it's considered delivered. So if you've emailed it out to that agent, even if they haven't receipted it, although I like to get receipted
Right.
proof of stuff like this, but technically in the court of law, as long as it was sent and it shows it was not undeliverable, then it is considered executed. So know that, yeah, the seller could have changed their mind and they would have been out of luck if your seller did.
No, I mean, ethically, I felt like I told her, hey, we're gonna do this. Yeah, that's fine.
Yeah.
Just because she couldn't, you know.
I mean, I've never
kind
actually
of-
had a client not do it, even if it's within an hour or two,
Right.
but it technically could happen, and I'm sure it has, but it's not executed until it is signed and delivered, even if they said they would do it. Just like an offer, just because you verbally accepted it, yeah, you're gonna look like a horrible person, but in the end, until it is signed and delivered, they don't have to, you don't have an executed agreement. So just, that's a big one, that you verbally accepted and then another offer shows up within 5 minutes. And if you've never sent it, technically the client could accept the other offer. And we'll get more into that stuff on the listing agreement side of things. Okay, title policy and survey. So seller shall furnish to buyer at seller buyer's expense an owner policy of the title insurance issued by the title company. So this is a negotiation. You would either check seller or buyer. Title policies, I always tell my clients they're roughly around 1% of the purchase price. That's high. It's more like 0.77. It's not 1%, but I would rather quote high than low. So that helps them understand what it's going to cost to pay for one, because a lot of times right now, multiple offers, buyers are paying for owner policies. If it's a buy sell situation, and again, multiple offer, if the seller had the buyer, or if they went and made an offer on a house and paid the owner policy, then typically they expect the buyer of their house to pay the owner policy. And so just know what you're going into, what market, and how much it typically costs. Now, I've seen a few of our agents do this and I've had to correct them. So I've seen both of these checked off, and that is not appropriate. You can do that, but then you have to explain somewhere, either on an amendment or in the special provisions, that the buyer and the seller are splitting the cost of the owner policy. The title company doesn't just automatically know that this means they're splitting the cost of the owner policy. So if you're going to negotiate that, you're gonna have to put that in writing somewhere else. Okay? I've seen that a few times lately, so I want to point that out. Now, this is one of the most confusing sections on the contract. This is newer. It says the standard printed exception as to discrepancies, conflicts, shortages in area or boundary lines, encroachments or protrusions or overlapping improvements will not be amended or deleted from title policy, or will be amended to read shortages in area at the expense of buyer or seller. So the best way I've learned to explain this is there's a lot has happened in the last 15 years of real estate. There's been a lot of title companies that have gone out of business. There's a lot of surveyors that's gone out of business. There's a lot of foreclosures and short sales and title company selling to each other and merging. And so within that, and I've had this happen recently, actually. Are you talking about the exclusions, Sinai? Like this part, the amendment part, or are you asking about the title policy?
Sorry, I was asking you the title policy, how to like get a price or.
Yeah, so I always quote 1%, but it's typically less. If you want to know exactly, there are either title apps that you can calculate exact amounts, or you can just call the title company and ask them how much it would cost for this purchase price. But I always quote clients around 1% and tell them it's a little less than that, but I like to quote high.
Okay, thank you. Sorry, I had missed that.
It's okay. So the amended part, so what happened is there was a deceased owner that was found. I was the buyer, not the seller. The property was a new construction, so it was a lot previously, and it had 3 owners prior to the builder building this house. And so when we went to buy it, they found a deceased heir on the property. So there had to be an heirship affidavit at that point. Well, it was bought and sold 3 times without this problem because title companies found it a low risk situation because it was like a $5,000 lot. But once a $170,000 house was built on it, it now became higher risk. And this particular title company did not want to waive that risk, and they were requiring us to go back to all the heirs and get heirship affidavits, or they'd have to go to probate. It was a hot mess. And this section, let me step back, the title company that sold it to the builder was no longer in business. And so what we would have done is gone to them and been like, hey, you should be covering this issue because there was a conflict and discrepancy. But because they were out of business, we couldn't do that. There was no going to them and saying, hey, we have title insurance for this. You need to do this deal and cover it. So what this does is basically adds an extra layer of title insurance if this ever happened when the new buyer goes to sell the property. If there's any fence issues, survey issues, encroachments, deceased, it's just an extra added layer of insurance for basically this title company to protect your client for when they go to sell it again. Or if someone shows up on their property and says, I own this house, and it got sold to them and they have no idea what they're talking about. This cost is variable as well. I've seen it as cheap as $200. I've seen it as expensive as $1,500. It is based off the purchase price of the property. I don't know the exact math on it. I haven't had a title rep be able to tell me exactly, because again, they just put in to their system the property and the contract, and it pops out all these numbers for them. So I don't know the exact math on it, but it's added layer of protection. Typically the seller doesn't want to pay this for your clients, but again, it's a negotiation. If it's a newer home, you're welcome to put will not be amended. Now that I've actually had 3 issues arise, I've had another client, one of our agents, have a situation where there was a well, and the well was being used off the property. It was a mess, and this was not checked off. And so we couldn't really get any type of legal help from the title company, because they didn't have any extra protection when they bought the property from a previous situation. So I would start saying, I used to not say this, but now that we've had multiple issues, I would start amending this. Something I'll do, and I'm gonna write this down, is I'm gonna get with my title partner and see if I can get a more accurate cost on this. 6A 8 cost. And I'll send that out, because I do think that added level of protection is going to be important just in case something shows up. But again, if your client's the one paying for it, they need to agree to pay that cost. So let me find that out a little bit more for you guys, and I'll send that out. Okay, commitment. So this is an automatic time. Within 20 days after the title company receives a copy of this contract, seller shall furnish the buyer a commitment for title insurance, and at buyer's expense, legible copies of restricted covenants and documents evidencing exceptions in the commitment other than the standard printed exceptions. If they are not delivered within the specific time, it will automatically extend to 15 days or 3 days before closing, whichever is earlier. So no, it's just not an automatic cancellation. They get more days to do it. So this is not something they get to cancel on. But if it's not within those days, then the buyer can cancel. So it automatically extends, and then if it doesn't happen, the buyer may terminate. You need to, we'll get further in, but once you get a copy of this, it is very, very important that you look at it too, because I have learned in Texas, the title companies don't always make the agent aware of any issues with the title commitment. And so I will have a title class with a title rep to explain a title commitment and go through it with you guys. But it is very important that if there's any liens, encumbrances, error issues, you guys know about it, because it can delay, it can cause issues with a deal, and that can affect your client. So do not rely, I'm going to make this very, very, very adamantly aware to you, do not rely on anyone else to do their job, because they don't seem to do it. So especially title companies with the title commitment, we need to look at Schedule C and be aware of if there's any issues with the property. Okay, survey. So 1, 2, or 3 are our options. Side note, if it's cash, you don't have to have a survey. That is up to the clients. title company does not require a survey with cash. So if it is cash and no one wants to deal with the survey, you don't have to check any of these. But if it is financing, a survey is required. Number 1 states that there is a survey. So if there is a survey on the property, you would check 1 within blank days after the effective date. I put 3. You don't want to give them too long because you want to be able to review the survey. Seller shall furnish to buyer and title seller's existing survey of the property and the T47. Now, if they don't do that, and know this from the listing side, if you don't deliver that, it doesn't mean you can cancel. It just means the existing, the seller is now going to have to pay for a new survey. It doesn't just kill the deal. The seller is just now going to be spending money on a new survey. So very important on the listing side. Less important on the buyer side because the buyer doesn't have to do anything about it. But if you're the sellers and you don't give the T47 and the survey to the other side, your seller's going to be paying for it, which most likely you're going to be the one paying for it, unless your client just drug their feet and didn't send you the T47. If the existing survey is not acceptable to title company or the lender, then the buyer shall obtain a new survey at blank expense. Typically, we see buyer's expense checked off, but again, this is all negotiation. So when writing a contract, I'm not going to say this is the exact box you have to check because it depends on the market. It depends on the situation of the seller and the buyer. And so there's not necessarily a right or wrong choice. It depends on the negotiation. So in a seller's market, I still have seen this be checked off at the buyer's expense most of the time. But that's not always the case. You could check seller. I personally come from a state that in Florida that required all new surveys. I think it's crazy that you're allowed to supply an old survey. And so I would think it's the seller's responsibility to pay for a new survey, but that's not typically how we find it negotiated here in Texas. Again, it depends on how bad my client wants the house and how many offers there are to what I would check. Number 2 is within blank days after the effective date of this contract, buyer shall obtain a new survey at buyer's expense. So this, since I'm representing the buyer, I don't want it to be 3 days. I don't want it to be 10 days. I don't want my client to have to spend the money prior to doing an appraisal and all that. So I typically put 21 days here because I want that to be towards the end or have the option to do it later in the contract. Because surveys have gone up in price. They have taken a little bit longer. So I've seen it be anywhere from $500 to $1,000 now, whereas they used to be like $250. So I don't like my client to have to spend that money because if you don't buy the house, you don't need that survey anymore. So just be aware, I put 21 days or 25 days. I try to make it towards the end of the contract. 3 is within blank days after the effective date, seller at seller's expense shall furnish a new survey. If the seller's paying for it, I shorten the window to like 10, 15 days. Again, I want to get through option period before I make a lot of people pay a bunch of money for nothing, but I do shorten that window if the seller does pay for a new survey. Okay, objections. Buyer may object in writing to defects, exceptions, or encumbrances to title disclosed on the survey, other items through 6(1) through 7. That's the title commitment. Disclosed in the commitment other than 6(a) 1 through 9. which prohibit the following use of activity. So a new one, or the most common one these days right now, is Airbnb, investment, rental property, putting a barn, a shed, a whatever you want to, your client specifically wants to do to a property that may not be allowed within the title commitment, the deed restrictions, the HOA. That's what you would put in this section. I was taught long ago to put residential use in here. It is not required. You see it over and over again. It was something some attorney taught us probably 5-7 years ago, and agents just do it. But honestly, the only thing that needs to really be in there is if your client has a unique reason for a property that may not be allowed as you get deeper into the transaction. If you know your client well enough, you should know if they're planning to do something unique to the property. And that's what should be on this section. If you didn't put it there, then they don't have the right to cancel based on it. Okay. And you must object earlier than of 1, the closing date, or 2, blank days after buyer receives the commitment, exception documents, and the survey. I put 3. Honestly, I'd probably up it to 5. I don't want my clients to have a ton of time to make a decision on canceling. 5 days should be enough to talk to the county, talk to the HOA, do your research. I personally find that too many days allows clients too long to think and not act. And that can stall a deal. So I would put 5 days here. If you don't waive your rights for that specific reason, you're done. Like, you can't go back and be like, I want to cancel based on it. No. You can't even cancel based on it right away. The seller actually has time to cure the objection if they want to. And it says right here, buyer's failure to object within the time allowed will constitute a waiver of buyer's right, except that the requirements in Schedule C of the commitment are not waived by buyer, provided seller is not obligated to incur any expense. Seller shall cure any timely objections or any third-party lender within 15 days after seller receives the objection. That's called the cure period. If the objections are not cured within the cure period, buyer may then deliver notice within 5 days, terminate the contract, or waive the objections. If you don't waive it, your buyer doesn't get to waive it the day before closing. This is all a time thing. This section is very important, that if there's issues, you follow the time restrictions. Because if you don't, and I'm the listing agent and you don't follow it, I'm going to eat you alive. Like, you have to follow these times or you don't get to, you can cancel. Please don't misunderstand that a buyer can cancel at any point in a contract. They just lose their earnest money if it's not done within the rights of the contract itself. So if you don't follow these days and these exceptions, your buyer can cancel, but they'll lose their earnest money.
So is that where you would put, like, if my buyers want to put a swimming pool and then we find out there's like an easement in the way?
Correct.
Okay.
Yep. That's the perfect place and absolutely where it should go. And that is important. I've seen that come up too, where this person's adamant about a swimming pool, you don't put it in there, and then you find out on the survey you can't put a swimming pool. Or I've had to, unfortunately, we've had a situation where we've had the seller put in a HOA pool request to get it approved and it not be approved. So, and you don't want your client to get to that point either. Now that's above and beyond. You don't, it's not honestly going to come back at us if the HOA denies their pool request once they buy the house, because it's not necessarily our job to have the seller put in the bids and all that stuff. But the survey is in the deed restrictions is our job to review and make sure that they can put in a pool. If their design doesn't get approved, then that's not on us. But if it clearly says no pools on lot 18 in the deed restrictions, well, you're in trouble if they ended up buying that house. So HOA. So I am learning more. The site isn't fully active yet. The first box is it in an HOA or not? Side note, the Woodlands is not in an HOA. So if you are in, unless it's a townhouse, condo, or it's in Carlton Woods, it is not in an HOA. So you would put is not. Now, there is a transfer fee for the Woodlands. So in special provisions, we typically put buyer will pay Woodlands transfer fee of X amount of money. That's if you do a deal in the Woodlands, just know that that shows up a lot. But other than that, if it isn't an HOA, you need to check it off. Now there's an addendum for this, which we'll go over tomorrow. They have now regulated, because HOAs were getting ridiculous and we're charging insane amount of money to just get the deed restrictions. They have now put a limit federally for these HOAs. And so there's going to be a mass website, or it's already live. I gotta find it again. It used to be posted on HAR. I'll find it again and send it out. But I've checked it a few times in the last couple weeks and it's not fully ready yet, but it's a database for management companies to create a login. It's not for us to create a login, but these management companies will create a login and post all their documents there. And it's one like national database of HOAs and their deed restrictions. And then I believe they can't charge any more than, is it $2.95 for the HOA docs? There's a cap on it now because it got ridiculous. Like some of them were like $750 just to give a set of documents via email. And so they've put a regulation on it, which is really nice for our buyer clients. I want to reference this number 3, statutory tax districts. If the property is in a utility, which is a MUD, water, sewer, drainage, flood, it requires the seller to deliver the disclosure. Now, I see a lot of agents reference the MUD down here on section 22, and you don't have to do that because it is literally right here under number 3. Okay, so all of these disclosures are right here: utility service, water, propane, gas, transfer fees, public. You don't have to put any extra disclosures in section 22 because it's all listed right there. If it's there, I'm not gonna deny your contract, but it's not necessary to put it there. Those are all just information. You can read those on your own. I'm less worried about those. property condition. This is probably the number one question I get from a client when they read this contract. It says that the seller shall permit buyer and buyer's agent access to the property at reasonable times. Buyer may have the property inspected by inspectors. Any hydrostatic testing must be separately authorized. But then it says buyer has received the notice or buyer has not received the notice. So this is seller's disclosure. So in this house itself, we did receive the seller's disclosure. So you would check off 1. If you did not receive it or it wasn't fully received, like if they did not fully sign it, they did not completely fill it out. So if there's any missing check marks, I would put it wasn't received and tell the agent, like, look, this one is not checked off. There's 2 missing. So just right there, I would personally, to protect my client, put number 2 and say it was not received and put 3 days to send it over. Because I don't want to sign anything that's not fully completed. So I personally would put number 2. The only time a seller is not required to furnish it is if it is a foreclosure in a state or owned by the state. So, and there was one more that I read recently, someone sent me. It was interesting. I think it was a condo. Didn't have to, it was, I'm gonna find out, but there was one I just learned that I thought was very interesting. You know what? I actually think I have it saved as
Duplexes.
a
I think it was
picture.
duplexes.
Huh?
I think it was duplexes, I think.
Duplexes, yeah. Was
because
it
when I
you who
looked-
sent that to me?
Yeah.
Yeah, duplexes. That was interesting to me. And I mean, it makes kind of sense because it's a share, although it's individually owned, it's a shared, like the roof is shared, but townhouses require it. So I don't know. But I saw that. I'm gonna follow up on that though, because I mean, it was on your test, wasn't it?
I got it straight from their website, because I didn't see it on the contract, or I was going through a contract.
Mm-hmm.
And it didn't specify anything on the seller's disclosure, so then I looked on their website and that's what the answer they gave me.
I'm gonna just call legal and 100% verify, but I mean, what you sent looked legit, so, but that's the first time I heard that. Lead-based paint, obviously, if it was built before 78, it must be disclosed. Now this is the one that sellers always get freaked out, or buyers. It says as is means the present condition of the property with any and all defects and without warranty except for the warranties of title and the warranties in this contract. They just read that and then they stop. The rest of it say after inspections you can negotiate, but they read that and they freak out thinking that they have to buy this house with all the defects. No, they are accepting it as is without any automatic negotiations until you do inspections. So if you check off 1, they're saying they're accepting it in the condition it is with this offer right now. And then they're gonna do inspections and we may renegotiate. Or you can check number 2 and say, buyer accepts it as is, provided seller is going to make these specific repairs by closing. So let's say the fence was half leaning and you already want the seller to fix that, then you could put that here in number 2. And then after inspections, that's when you would renegotiate. And please know from a buyer standpoint, the condition of the property has to be at closing the same as when you execute this document. So if there is a giant hole in the wall and you don't negotiate it, that hole in the wall stays technically per contract. Now, if you renegotiate it during inspections, that's different. But if you don't negotiate that hole in the wall, then that hole in the wall is going to be there at closing. So it's the condition it is at the time of the execution of the contract. Unless there's like a hurricane, a flood, then that's a natural disaster and the seller doesn't have to fix that, but that's later in the contract. Okay. If the appraisal comes back and there's lender required repairs, if the cost of the repairs and treatments exceeds 5% of the sales price, buyer may terminate of this contract. Technically, the seller doesn't have to complete the lender required repairs either, by the way. And that's on the addendum, which we'll talk about. Completion of repairs. Unless otherwise agreed, seller shall complete all repairs prior to closing date, and required permits must be obtained, and they must be performed by licensed providers if a license is required. Plumbing, electrical, AC, roof. Am I missing any? Plumbing, electrical, AC, roof. Those are required licensed people. You cannot have unlicensed people do the repairs. The seller cannot do repairs unless they are licensed. So that is one of the biggest issues too, because we find that sellers, and I will tell you from a buyer standpoint, I really try to keep my repair requests minimal, because a seller is going to try to find the cheapest person, the fastest person to fix something in most cases. And so I would prefer money or my client to do the work in my opinion, but it doesn't always end up working out that way. But just know that most sellers are going to try to do it the cheapest and fastest versus the most quality. So I try to ask for money in most manners. Residential service contracts. These are the home warranties. These last for a year. They're paid by the seller if you ask for it at closing. Typically, they're around $500 minimum now. Depending on if there's a pool, a septic tank, multiple fridges, it could be all the way up to $1,500. So in a seller's market, we've seen less of this, but in a buyer's market, we see this all day long. So it's a negotiation tool. I wouldn't put less than $500 in here for a basic house, because then your buyer is going to have to bring money to the table to pay the rest of the home warranty. We'll do a class on home warranties for those who don't know them. I'm not going to spend my time on that. Section 8 is if you are in ownership of 10% of the deal. So if you are acting on behalf of a spouse, a parent, a child, that you are ownership of 10%, you must disclose that you are a licensed Texas real estate agent. Now, I always caution on the side of more disclosure is better. So if it is my brother, my parent, my spouse, and I still don't own 10%, I disclose it, but you technically don't have to. It's if you're going to own 10% or more. Closing. This is the closing date, on or before or within 7 days after objections, whichever date is later. Please make sure it's not a holiday or a weekend that you choose, and or that your client's going to be in town. Like, unless you already know your client is going to sign mobile or out of state, try to make sure that the closing date is what your client wants and that the lender can satisfy as well before picking a closing date. So yeah, there you go. Make sure it's not a holiday. You guys can read this. It's nothing really major. Possession. So you're either going to put upon closing or according to a temporary residential lease. So if the buyer or seller is going to stay, or if the seller is going to stay on the property after closing, you would check off according to the temporary lease, or if the buyer is going to move in prior to closing, you would check that off. Otherwise, it would be upon closing and funding. This is also the section about the smart devices, that it becomes a fixture. So you can read that on your own time, but I've already explained it. Special provisions, you have been taught during your courses to not touch this section. You could be considered writing law. You can put factual statements such as buyer seller are splitting 50% cost of title policy. Factual statement. If your client wants a certain language in here, they can type it and you can translate it into this section. There are ways to write in here, so don't be insanely scared not to ever put anything, because I will at times tell you to put something there, but you can't just loosely write statements and special provisions because it could be considered practicing law. Section 12 is if your client is needing closing costs. So the lender will the lender will tell you this. If they need closing costs help, this is where you would put this. So let's say that we're offering, most $800,000 clients are not going to ask for closing costs help, but some FHA, VA, USDA, assistant programs, they will need closing costs help. So you would put, let's say $5,000 here, and that means the seller is going to literally give $5,000 to the closing money on the CD. The biggest note here is if you go to do an amendment to this section, you have to put the new total amount. Don't put I amend another $2,000. You're literally changing this number to $2,000 then. So if they need you negotiate $10,000, that amendment better have $10,000. That's a big mess up on your part if you don't do this correctly. So this will get put at closing for the client. Prorations, taxes and interest, maintenance fees, assessment dues, rents, all of that gets prorated to closing date. Casualty loss just says that if the property is destroyed by fire or anything that the client couldn't control, then the seller can either terminate or extend it to 15 days to get the property back to where it needs. Default, the seller and the buyer can be in default, and we just go from where they're at in the deal and negotiate and release earnest money based on who defaults and why. If we can't come to an agreement, we go to mediation between broker to broker. If it doesn't work out in mediation, then we start adding attorneys. The client, I've read through this and I highly recommend you read through this yourself, but I want to make note that whatever person fights for the money, and if they are wrong, they end up paying all the attorney fees. So if they wrongfully fight for earnest money and it is found in court that they wrongfully requested earnest money, then they're the ones who are going to pay all the fees that were incurred. So it's not just paying back the escrow money, they're going to incur all the attorney fees from both sides. And it says that in all this pay 18 it goes through all that legal jargon, so I highly recommend you reading it. But that's what that says. Okay, if it's a foreign person, just note that they are gonna have to withhold funds on the seller side. So if the seller is a foreign national, the title company will automatically, I believe, retain 30% of their proceeds for tax purposes, and then they go through a process to release those funds to them. I know we're 5 minutes over, we're almost done. The rest is pretty fast. Notices, so this is the buyer's information. This is the seller's. You fill out what you have for the buyer. Agreement, so these are all the documents. So this is very, very important because we're dealing with this right now. Just because it's checked doesn't mean it's truly a part of the contract. So if you check off third party, it's in an HOA, you're gonna do addendum, lender's appraisal addendum, and let's say a sale of another property. Let's just say that. These addendums are not a part of the contract unless they are executed with the contract. So I want you to make sure that you don't execute a contract without these addendums. Because we are fighting one right now that we are not in the best position here. The seller is in the best position at the moment. So know that you don't want to execute this agreement until you have all these documents. If there is an attorney involved, that's where 23 goes. This is the execution spot. Do not accept this contract executed if you are not the final one signed, like the final person signing and delivering is the one who executes it. And so if you haven't gotten all the documents from the other side and they send you this executed, you immediately say, no, this is not executed on this day due to this, this, and this. I need these items before this can be executed. It is the last person to sign and deliver that executes the document, because that starts day 0, right? The next day is day 1.
What happens
Lastly, oh, did someone
Sorry,
have
what
a question?
happens is that if the last person, so the listing agent doesn't execute it, I've gotten it back before without having anything on there, so I've put the date on there and sent it to title.
That works. That's just fine. So if they send it back to you without it, then, and it is correct that today, that time is executed, then I would put it on there for them and send it to all parties. But just make sure for full clarity that you have every document you need before you execute. Now, I'm going to side note, if they haven't given you the lead-based paint, if they haven't given you the mud, if they haven't given you the T47, those are disclosures. Those are not negotiation addendums. I want to execute without those as the buyer because there are rights to cancel based on that. So know who you're in representing and what position you're in to have more power. So on the buy side, the addendums you need executed before you fully execute this contract. Not the disclosures per se, but the addendums. Please try to have this fully filled out. It obviously fills out some information for you, but please put our license number that you're representing the buyer, the seller's representing the seller, your phone numbers. I'm your licensed supervisor. You can find out a lot of this information on MLS. If you click on the list broker info, it will give you who the office manager is and their license number. the ad phone number. You have all the information you need. Honestly, you're just being lazy if you don't fill it in. And then down here, I've seen a lot more people put the percentage of sales price. Again, there must have been a situation where someone got paid whatever the contract price was and not the actual closing price. So you're welcome to write 3% of sales price or whatever is offered on the MLS. So if it's offered as 2%, then you're gonna have to put 2%.
I've seen it was recommended that we have to print the listing and put it on, back agent, but sometimes they recommend also printing the listing before you put, or when you're putting the offer, because sometimes the agents will change it.
Yes, I would advise to know what that is, print it. Honestly, if you knew that it was 3% and you made the offer with the 3%, if they go and change it, HAR has record of that, and I, as the broker, can submit a dispute and they will take the person's listing agreement. They can see if someone goes and changes it. So then that's a big, and from you guys' standpoint, this is a offer on the MLS. You cannot just go and change this after an offer is made. You can change it prior, but once the offer is officially in your box and it was made as an offer to someone, there's a lot of fight with this. I don't know that they're going to even allow changing it anymore. They used to be a little more flexible, but please understand, once it's on the MLS, if you've offered the 3%, it's considered an offer and you don't change it. And that's a big red flag for MLS and HAR and TREC. If you do something like that, and that's a fast way to get your license suspended. And they're cracking more and more down on this. This year, they're disclosing publicly what a buyer's agent is being offered to the clientele too. So there's a lot of changes happening. They're going back and forth on that. There's literally a lawsuit happening right now in the federal government around disclosing commissions. So we'll see what comes of it, but they are planning to start disclosing our commission percentage on the buy side to the public. So if you start making changes like that on the sale side, or if you notice that's something I want reported right away, because that's a big red flag.
Yeah, I think because the conversation had come up that someone had gone into contract, and this is in one of my little groups, and at the bottom of the contract, they had 3%, but come to closing, they only had like 2 or something.
Mhm.
And that's when they were disputing, is it what's on the contract or what's on MLS? And I think they decided it's what's on MLS.
It is on what's on MLS. So you can't and that's a side note, good statement. You can't ask for more money from the agent. That is not allowed. That's a big no-no. That's an ethics violation. Like if they disclose 2% and you go and put 3% on the contract, that's not okay. Now, what's not okay is if you put 3% and the agent goes and changes it to 2%, but you can't go and say, well, I want more money. No, the person that you have to go ask for more money is to your client. That's who would pay you the difference. If you're saying my standard is 3%, because that's what I charge, because remember, there's no national commission standard. Again, you'll lose your license if they find out you say that. There is a personal standard. You can say, I won't work for less than 3%. But if the buyer's agent or if the seller's only offering 2%, then you have to go ask your clients for the 1%. So please be aware of how that works. The last page is option and earnest money receipts. I do require those for the contract. If there is an option, there's always earnest, but if there isn't an option, obviously it's waived. If there is, I need both receipts. That's it. That's the 1 to 4. We went 15 minutes over, so I apologize for that, but I hope this helped you. If you have any questions individually, please let me know, but tomorrow we're gonna go over the addendums of the contract. So that's gonna be the focus tomorrow, and then Thursday, we're gonna go over the listing agreements. And then Friday, we're gonna work on CMAs. I would like a group consensus. Would you guys prefer all weeks classes to be Zoom or just the because right now I have it set up as just the contract classes are Zoom and Wednesday and Fridays are in person. But I'm happy to switch it to Zoom if everybody else would prefer Zoom.
I would like Zoom due to my schedule.
I
Got
also
that?
like to.
If everybody else can agree with it.
Zoom works better. Same.
Same.
Awesome. So I will switch the other two to Zoom. I still hope to see your beautiful faces in this office because I don't want to be here alone, but I will make all the classes this week Zoom. And I do believe we do have better attendance that way. So thank you guys. I'm going to shut today's down. If you have anything you need, side note, give me a call, okay?
Thank you, Lena.
Thanks, guys.
Bye, thank you.
Bye.
Bye.